I was partially at fault, so I can't recover anything. That's not true, especially here in Florida. And believing that myth can cost you tens of thousands of dollars. My name is Cary Woods II. I'm a Florida personal injury attorney. Today, I want to explain to you the truth behind accident claims when you're partially at fault. If you've been in an accident and you don't know where you stand, this is exactly the type of information that can protect your claim, and I'll show you why. Florida follows what's called Modified Comparative Fault under Florida Statute 768.81. Here's what that really means in plain English. You can still recover compensation as long as you are 50% or less at fault for the accident. However, your total compensation is reduced by your percentage of fault. So let's say your total damages, medical bills, lost income, pain and suffering, add up to $100,000. If you're found 30% at fault, you don't lose your case. Your recovery is reduced by 30%. That means you could still recover $70,000. But here's the key line that you need to remember. If you're found more than 50% responsible, you recover nothing. This is exactly why insurance companies are so aggressive at shifting blame. Their goal isn't to be fair. It's to reduce what they have to pay you. Fault is not always black and white. It's often subjective and something that a jury could decide. That's why how your case is presented and how the evidence is handled matters so much. I had a case recently where a client rear-ended someone. The driver in front of him had brake lights which were not working. Typically in Florida, the rear driver is presumed to be at fault. But I was able to overcome that issue by demonstrating that the vehicle without its brake lights being operational was a dangerous condition and therefore contributed to the motor vehicle accident where my client was injured. The important takeaway is this. Partial fault does not mean the end of your case, unless you allow the insurance company to control the narrative. If you think you might be partially at fault, here's what protects your claim. First, don't admit fault. Not at the scene, not to the other driver, and definitely not to the insurance adjuster. Second, gather evidence, police reports, photos, video, and witness statements. All of this matters. Third, document everything, especially your medical treatments and how the injuries affect your life. And finally, be very cautious with insurance companies. Never give a recorded statement without legal advice. If you've been injured in an accident and you're worried about being partially at fault, don't assume you're out of options. In Florida, the law may still be on your side, but timing and evidence matter. Reach out to my office to talk through your situation. The sooner you protect your claim, the better your chances are at recovering what you deserve.